And counsel, your appearance, please.
Good morning, Your Honor. Daniel Mercier, P72620, representing the petition. Who is not present here right now? This is.
Okay, and so the court will make a record that Mr. Mercier had asked to approach and address the time that he could be present today for this court to issue its ruling on the preliminary examination that was conducted in October, on 2 different dates in October. This matter was set for the parties to return at the end of November with briefs to be completed by November 15th. There were a couple of adjournments for the transcripts to be completed. I understand it was through no fault of counsel. And the court's going to note that the Attorney General is not present at this time because this matter is scheduled for today at 11:30 a.m. Mr. Mercier asked to, or I presume was telling the court that he was not available at 11:30 and he had it in his calendar for 8:30. Is that correct, counsel?
I just was informing the court I would never be so bold to tell the court anything. Thank you, Your Honor.
And the court then, as this was off the record, the court then informed Mr. Mercier that this matter was scheduled for 11:30. And counsel, you indicated that you had it in your calendar for 8:30. And then you requested to appear via Zoom. I stated I was going to step off to confirm whether or not the Attorney General was appearing in person or via Zoom, because there was a request by Mr. Payak to appear via Zoom. However, if that was not acceptable, he was going to have somebody else appearing in his place. He sent the email to the court as well as yourself indicating that a different assistant attorney general would be appearing in his place, which tells me that that person's going to be appearing in person. As the court was leaving the bench to go look at it, Mr. Mercier made the comment that to refresh my recollection, because that I made his client come in person because I don't like him. This court made it very clear that that was not what this court ever stated, and that was a mischaracterization of anything that this court has ever stated. Mr. Mercier, I am unsure as to where you came up with that conclusion, but because this is a criminal matter that involved a lot of documentation because of the charges, this court required your client to be present. It's a criminal matter for an in-person preliminary examination. At no point did this court require your client to appear in person because it did or did not like your client.
Your Honor, I wanted to clarify that, and I attempted to while we were off the record, is that I had previously asked if my client could appear by Zoom because he lives out of state at this point, where he did not previously, and the court informed him that you had previously informed my client that I believe the arraignment, or maybe a hearing that I was not at, that all hearings would be in person, and that he had knowledge that all these things would be in person even prior to me making that motion to it. I did not mean to say did not like him. Off the record, I didn't say that. I retracted. I hope I have clarified that. But I was trying to reference back to the fact that you said, did somebody make a motion for Zoom? I was going to say, I actually made that motion for Zoom. And it was denied because of the fact that he was already notified that these would all be in person, even though he's out of state. And so that's what I was trying to refresh with. And I'm sorry if we had a miscommunication. I own my part on that.
Counsel, there's no miscommunication. You clearly stated that you were trying to refresh my recollection that I made sure your client came in person because I didn't like him. There was never any statement to that effect, nor any communication otherwise, as I stated, and I stated as you just did at the arraignment that these proceedings would be in person.
And I was not at that hearing. I was at a later hearing where I made the motion. I attempted to clarify, and obviously I did a poor choice of words earlier, Your Honor. I hope that clarification here on the record allows the court to know I get complete deference court. I understand. I meant I did not mean to upset the court.
I don't even know why that comment would have even come out of your mouth, counsel. Quite frankly, I have no idea why that would have even come out of your mouth. That's not a miscommunication. That's not trying to tell this court what I stated at the arraignment or otherwise.
Well, I appreciate the opportunity to clarify, Your Honor.
And to the best of my understanding, the Attorney General is going to be in person. This court scheduled this matter at 11:30 based upon its docket. And so this matter is set for 11:30. I can't hear it before that. I don't have the Attorney General present. And you put it in your calendar for 8:30. I'm not sure why. On December 5th, the email was communicated from Ms. Shelton to both you and Mr. Payak that stated verbatim, after conferring with Judge DeSanto, we have agreed upon Thursday, December 21st, 11:30 a.m. for the exam continuation with briefs to be due to the court by December 14th. We understand this is a busy time with the holidays and all, but there are literally no other options based upon our dockets and the court's holiday closures. That was the communication on that date. The court received Mr. Payak's brief on December 14th. The court received your brief on December 18th and then another one on December 20th. Which was yesterday. And there wasn't any request to have this matter moved up in time or that there was a conflict on your schedule or otherwise. And that email was sent at 9:12 a.m. on December 5th. Over 2 weeks ago. And so counsel, that's at 11:30. I can't do it before that. I don't have the Assistant Attorney General present.
Your Honor, I am scheduled, and I apologize about the calendar issue. That email, by the way, cited, I did not respond to. If I saw that email and saw the time, I would have identified the conflict previously and would have been in contact with your court. I also would have informed the other court when they scheduled the third day in Chief Judge Latoya Miller's courtroom and for a third day on an adult juvenile bindover case, today to start at 10 o'clock, I would have said I was not available. But now I'm in a difficult situation here, Your Honor. I was attempting to approach you off the record to bring it to the court's attention that with this case being adjourned so many times, in this case, the other case also being continuing, that I kind of I'm in a pickle here. I'm looking to the courts for some guidance and direction. I did not mean to upset the court. I understand the situation. I'm kind of in. I will
counsel, at some point you had to have seen the email because you had it on your schedule for today.
I did not process the time, Your Honor.
Counsel, you're telling me two different things.
I will call Chief Judge Miller's when we're off the record, Your Honor, to see if I can move
counsel,
back, okay?
You're telling me multiple things. One, you're telling me that you had it in your calendar for 8:30. The other, you're telling me that you didn't see the email. And now when I called it to your attention that you must have seen the email because you had it in your schedule for 8:30 today. Now you're telling this court that you didn't put together the time difference. I don't know what it is.
In my electronic calendar, Your Honor, I changed the date, not the time of the previous, how I had it in my calendar.
Okay, but you did receive the email.
I did receive the email. I didn't process the time change, Your Honor. I'm not saying different things. I'm saying I look at my electronic calendar on my phone and I only changed the date, not the time. It's not a date issue, it's a time issue, Your Honor.
I understand that that's what you're saying right now, but you also just a few moments ago stated to this court as an officer of the court that you did not respond to the email because you didn't see it. But you did see it because you changed the date in your calendar.
I didn't see the time in the email, Your Honor. That's it. It's a time issue, Your Honor. I'm only was talking about the time.
And so what is this in which court are you in?
I am in Chief Judge Latoya Cynthia Miller's courtroom. It is a juvenile adult bind-over case.
And that's Third Circuit?
It is Third Circuit. It's on its third day, Your Honor. And I actually was hoping that it would have been over previously. It wasn't. The date that was scheduled for yesterday that it may have been over was canceled by Chief Judge Miller. And now and so today is a go.
So is this the first day or the third day?
This will be the third day of this hearing. For today, yesterday, I believe we also had a hearing on the 18th, and we had a hearing even before that. So this would be the third day. I was gonna ask the court if I could appear by Zoom. I could go to the courtroom there and ask Chief Judge Miller if I could step out into the lobby and appear by Zoom.
And what time is that supposed to start, sir, counsel?
10 o'clock, Your Honor.
Off the record, you told this court you had a bench trial that was scheduled from 10 to 4:30.
That is a bench trial. Miss Miller is the one sitting on the bench, Your Honor. It's in front of her.
What?
Miss Miller, it's not a jury, it's in front of her. It's a bench preliminary exam, Your Honor, in front of Judge Latoya Miller.
Okay, that's not a bench trial, counsel.
Very good, Your Honor. Thank you for that clarification. It's in front of the bench. I was speaking quickly off the record, Your Honor, trying to explain my situation with the time.
Counsel,
What do you want?
you're a seasoned practicing attorney. You know the difference between a preliminary exam, a bench trial, and you told this court off the record you had a bench trial scheduled. There is a difference between a bench trial and a preliminary exam.
I feel we're splitting hairs, Your Honor.
We're not splitting hairs. I want to make sure that I am not being misled. That is what I want to make sure of, counsel.
You are not.
Because at this point, I have some concerns. So we're going to go off the record for a
You're not being
moment.
misled, Your Honor.
We're going off the record.